This was the motion for her to dismiss Treena Kay, the prosecutor, for misconduct in Lori's eyes. You can see here, the defendant, Lori Daybell, hereby requests that both case numbers listed above be dismissed for prosecutorial misconduct committed by the state's attorney, Treena J. Kay. So she mentions two cases. For those of you not familiar, the case we're talking about that goes to trial next week is the death of Charles Vallow. She's facing a conspiracy to commit murder charge there. A separate case is the shooting, the attempted shooting of Brandon Boudreaux, her former nephew. That one will go to trial in a few months. She's saying that Treena Kay, who has been the prosecutor on this case with Maricopa County, should be dismissed because, in Lori's eyes, she says it was all about prosecutorial misconduct. So, what does she allege that Treena Kay did? Well, we have it right here. On or about September 6, 2024, Treena Kay directed the Chandler Police Department and the Gilbert Police Department to refuse to provide public documents to the defense, interfering with the defendant's right to conduct an investigation. So Lori's saying that she wasn't given documents that Treena told the police departments, Gilbert and Chandler, to not give her documents. So that's the allegation in count in number one. Number two, on or about January 30th of this year, Treena Kay obtained and distributed attorney-client privileged communications between the defendant and her appellate attorney in Idaho. Lori is saying that Treena Kay got information that she shouldn't have, messages or communication between her attorney here, who's handling her appeal, and Lori herself. And number three, that on or about March 11th of this year, Treena Kay gave legal advice to defense witness Nate Eaton in a, quote, off-the-record conversation regarding how to avoid being served with a subpoena from the defense. Ms. Kay has personally thrown her ethics and duties out the window in order to win this, quote, high-profile case in front of a worldwide audience. Lori goes on to say, because this court has ignored the state's conduct, Treena Kay became more blatant in her disregard for her ethical obligation. This is sadly similar to her longtime boyfriend, Juan Martinez's behavior in a, quote, high-profile case years ago here in Maricopa County. It seems her behavior is not original. The court is obligated to discipline officers of the court for misconduct. This conduct is egregious and needs to be addressed by the court. The actions the defendant is seeking this court take are as follows. 1, removal from both cases. 2, sanctions. And 3, disbarment by the state of Arizona. So these are big allegations. Well, these are big penalties that Lori is calling for. And she's making it personal by bringing in Treena Kay's boyfriend. Juan Martinez was worked on the Jodi Arias case years ago in Maricopa County. Now, I want to tell you that, well, actually, I'm just going to let Treena Kay respond because that's exactly what she did. She says the state of Arizona, through undersigned counsel, requests this court deny her motion as there has been no prosecutorial misconduct. The state responds to each of the 3 allegations by noting that, quote, the facts, as alleged, by noting the facts by the defendant as to each issue. Number 1, on September 6th, the state became aware that the defense had made a public records request to the Gilbert Police Department. The state emailed defense counsel and asked them to request these items from the state. The state also requested that the documents listed in the defendant's public records request from Gilbert. So they requested these documents that Lori Vallow Daybell wanted. When the state obtained the documents the defense requested, the state disclosed them on October 1st as, I think that means date stamped pages, maybe it means bait stamped pages, 1000, On September 18th, the state became aware that the defense had made a request to the crime analyst section of the Chandler Police. The state was advised that the defense request was improper because it was made to the crime analysis section rather than going through the public records request process. So, sounds like the defense requested the documents but didn't do it the right way. The state was advised the Chandler Police Records Specialist section spoke with Laura Moyse, who sent a request for, quote, log records for all digital devices downloaded. The state was also advised that the Chandler Police did not know what was being requested as, quote, log records. Chandler Police Records Specialist advised Laura Moyse that when computer crimes detectives are involved in a case, their reports contain downloaded information on all devices from Chandler Police. All reports related to the download of Charles Vallow's devices had been previously disclosed to the defense. Additionally, all extractions related to Charles Vallow's device have been disclosed. So the state's saying what you're asking for, what you requested, they've been disclosed. You have them. On September 19th, the state filed state's motion for defense to comply. On October 15th, the court issued a minute entry denying the state's request. The state is unaware of any other public records request to either Chandler Police or Gilbert Police by the defendant or her defense team. So Lori Vallow is claiming in that first point that they withheld evidence from her. The state is responding and saying, no, we didn't. The stuff you wanted, we gave to you, and there's nothing more. Point number 2. On February 6th, these are about the jails, the allegations that Treena Kay withheld or read attorney-client privilege between Lori and her Idaho appellate attorney. On February 6th, the state disclosed that jail calls made by Lori Vallow between October and January, as well as jail messages and photos from Lori Vallow's tablet from October to January. On March 18th, the defendant filed a motion to dismiss for violation of attorney-client privilege. The state is currently working on a response to this motion. The state hereby incorporates its response to defendant's motion to dismiss for violation for attorney-client privilege as part of this response. So it sounds like we're going to get something bigger on this particular issue. Issue number 3, the fact that Lori Vallow says that Treena Kay gave me advice on how to avoid a subpoena. This is how Treena Kay responds. On March 6th, the defendant filed a notice. The state requested that separate notices be filed for each cause number so the state would know which defenses and witnesses applied to each case. On March 7th, the state learned that defense noticed witness Nate Eaton is a reporter from Idaho. On March 12th, the defendant filed a supplemental notice. March 16th, the state filed a motion to preclude all witnesses on her supplemental filing. So that's a lot of words, but basically, the state filed a motion to have the people on that witness list precluded, not included to witness, to testify. At the final trial management conference on March 18th, the court heard from parties on this motion. The state advised that it did not have contact information for most of the witnesses. The state also advised that one of the defense witnesses, me, was a reporter. Nate Eaton contacted this prosecutor. I missed the page there, sorry. Nate Eaton contacted this prosecutor after court on March 18th, and this prosecutor called Mr. Eaton back. Mr. Eaton advised this prosecutor that his knowledge about the case comes from his interviews and investigation as a reporter. Mr. Eaton also advised that he had not been served with a subpoena by the defendant and he hoped to be in court for the trial. The prosecutor advised Mr. Eaton that even if he was not served, he still could not be in the courtroom if he was a noticed witness, and the rule of exclusion was in place. The prosecutor advised Mr. Eaton that this prosecutor would try to interview the witnesses and file a motion to preclude those that should be precluded at the end of the next week, which would be this week. The prosecutor did not advise Mr. Eaton how to avoid service of the defendant's subpoena. So what I can tell you based on both of those responses that Ms. Kay's response is accurate. For one, Lori Vallow Daybell said that on or about March 11th, Treena Kay gave me legal counsel. I have never spoken to Treena Kay in my life before March 18th. So that is wrong, on or about March 11th. I did say on Courtroom Insider that I had spoken with prosecutors and defendants. I did not say where those prosecutors and defense attorneys work, but I've spoken with several, not necessarily in Arizona or in Idaho or in other states. So we will see what happens with that.